Do you get paid every week or?
I get paid every week, but like I just said, my issue is my car is in the shop. So, and I'm
What kind of
on a
car
long.
is it?
That's a 2016 Fusion.
Ford?
Yeah,
Never
it
had a
was
problem
mom's
with it.
car. Yeah,
I'm a Ford guy. Just
but
keep running.
they
I don't
want
know what
thirty
you can
five
do
hundred
to
dollars to
a car.
fix the car.
No.
So,
Right. Here's what I'm gonna say to you. I could put it out to next week,
okay,
but we're really trying to get February paid,
correct.
right? So if I put it out to the 27th, maybe over the objection of plaintiff, will that give you the sort of the room to make sure you can get? All right.
This courtroom session is a raw, unfiltered look at the reality of eviction court, where rent deadlines collide with car breakdowns, job losses, and bureaucracy. In just one docket, we're about to see tenants scrambling to hold on to housing, landlords pushing for payment, and a judge walking the tightrope between empathy and enforcement. You'll hear tenants promise payments tied to tax refunds that haven't arrived yet, emergency assistance applications still pending, and even someone forced to choose between fixing a car or paying rent, a choice that can decide whether they keep a roof over their head. Watch closely, because these cases reveal how eviction court really works. Adjournments, conditional agreements, partial payments, and legal deadlines that don't stop for personal hardship. Some tenants get extra time, others don't, and one wrong calculation or one late check can tip everything toward eviction. So as we go through these cases, ask yourself, when someone truly can't pay, should the court bend? Or does responsibility still come first? Let's step inside eviction court.
Let's see where we are in her case.
We
How much is
submitted
owing
a
on her?
dismissal, Your Honor. My understanding was that Ms. Stafford was maybe not in agreement with the dismissal. I'm not sure exactly.
I'm just wondering if that was because of the little pay thing on the internet. It didn't get the money in time because I paid it, and then you still. This is why I'm still here because I know I owe for February.
It was adjourned, Your Honor, to ensure that the payment cleared. Since it did
Right.
clear, we submitted a dismissal. Ms. Stafford has received a 7-day demand for the February charges, which may be sent over potentially after today for filing. I believe that the suit will be filed on
Got
Monday.
it. Okay. So that's right. We adjourned it out because you just had to wait for the check to clear. There was going to be a dismissal
Okay.
of the case. But then you probably received a notice for your February rent. And so that can get a bit confusing, but okay.
Your Honor, my apologies. They were issued a 30-day non-payment demand, so
30 day.
7-day. So that being said, there was hearing date won't take place until I don't know sometime towards the end of next month, maybe not even into April. Your Honor, I would propose this if Ms. Stafford was open to this. That in lieu of
Filing a new case.
filed and incurring new costs, we could keep the case open and reach an agreement with respect to February. That would at least take care of February. If she fell behind for March, then we'd be in a different position. But I'd be agreeable to that if Ms. Stafford is.
Yeah.
I think I was going to suggest that myself because that way, if you can get an agreement, then you don't get additional court costs if they got to file it.
I was going to say, because they already made it clear that they're not renewing my lease. So I have until April to move out anyway, but I don't plan on jumping ship on them. So, yeah.
Okay.
Yeah.
Okay. So why don't I do this? You're paid, she's paid through January, correct?
January.
Right?
That is correct. And Your Honor, give me just one moment. I can give you the exact dollar amount as Patty did send me the updated ledger. So yes, paid through January. The current balance for February is $1955.60.
Got it.
All right. So when do you think you're gonna?
Oh, it's so complicated because my car decided that it needed a rack and pinion, but I want to get the rent paid by next Friday.
By the 20th?
Yeah.
Think you can do that?
Yeah, I'm gonna pray on it.
Okay. Are you going to be able to get it paid early in the day by next Friday?
Yeah.
Okay. Ms. Stafford,
Yes, sir.
You're leaving the case open. We're going to try to get this resolved for you so you don't have added costs. Do you think you're going to be able to do it by that day, or? I mean, just, do you get paid every week or?
I get paid every week, but like I just said, my issue is my car is in the shop. So, and I'm.
What kind of car is it?
That's a 2016 Fusion.
Ford?
Yeah.
Shouldn't have had
It
a
was my
problem
mom's
with it.
car. Yeah.
I'm a Ford guy.
But
Keep running.
They
I don't
want
know what you did to that
$3,500 to
car.
fix the car. So.
No. Right. Here's what I'm gonna say to you. I could put it out to next week,
Okay.
but we're really trying to get February paid.
Correct.
Right? So if I put it out to the 27th, maybe over the objection of plaintiff, will that give you the sort of the room to make sure you can get it paid
Oh, absolutely.
by the 27th?
Yeah.
Okay, let me do that.
Okay.
Okay.
Your Honor, what I would request under those circumstances, and this scheme is a mutual benefit of both parties, but at the same time, if it's not paid before we come back on the 27th, I would request that a judgment enter with the writ date running from the 20th, since that's the date that Ms. Stafford has indicated she could pay. That would
I
put her
see what you're
March
saying.
2nd. So it would run 10 days from next Friday versus 10 days from the 27th.
You follow that?
No, I need that in English.
Okay. What that means is the time period would be shortened.
Okay, because it's not 31 days in the month.
Well, no, the time period would be shortened because I'm going to go 2 weeks out instead of 1 week out to try to get you to.
Okay.
Okay, but let me ask you this. You got to get the rack and pinion fixed. You got to get that done. How much do you think you can pay to them on the 20th? I mean, just trying to get your vehicle fixed, trying to do that. What can you give them on the 20th?
At least 1,500.
So you can give them 1,500 on the 20th?
Yeah.
And still get your car done?
Mm-hmm. You'd be surprised. I work crazy hours.
No, that's okay. I'm not surprised. I just want to make sure you're all right.
Yeah.
So you know what I'm going to do?
I promised you I would get it done the last time.
No,
right?
I'm not. You know what? I don't doubt you. I just want to make sure I have it right. Okay. So I'm only going to go 1 week out. Get the 15 in.
Okay.
All right. And then I'll go from there.
Okay.
Okay.
All right.
So you're going to get 15 in. I know that won't get it paid, but let's do that. And get that paid as early as you can before the 20th. If
Okay.
you can, or early on the 20th. So that'd be the 20th at what, 1 p.m.
Okay.
Okay, get that in there.
Yep.
All right?
So,
All right. Take care.
thank you.
What you're seeing here is one of the most common tools in eviction court, the conditional adjournment. The judge is essentially giving the tenant a short extension to make a partial payment, in this case $1,500 toward February rent, to avoid immediate judgment. But notice the strategy. The judge narrows the timeline from 2 weeks back down to 1. Why? Because courts try to balance compassion with enforceability. If deadlines stretch too far, landlords lose leverage and cases stall. There's also a deeper reality here. The tenant is juggling essential expenses. Fixing a car might sound unrelated to rent, but without transportation, income stops, and rent becomes impossible anyway. Judges see this constantly. Tenants choosing between survival costs and housing obligations. So here's the question for you. If you were in this position, car or rent, which would you prioritize?
Spice Street Apartments versus Mbusu. Northfield Estates versus Elvira Harris. Hello.
How are you, sir?
Good. And what is plaintiff's claim in this case?
With costs, Your Honor, $4,873.19. Your Honor, I do note a payment of $350, which Ms. Harris had indicated at the last court date.
Last week.
So she did make that pay.
Yes.
All right.
I went to DHS. I'm waiting to
Hold on a second. You got to speak up.
I went to DHS. I'm waiting on a response from them. I just currently started another job. It's just been a lot.
Okay, you paid the 350, so you got some of that down, but so you went for an SER.
Yes.
How many people are in your apartment?
It's just two adults.
Pardon?
Two adults.
Two adults. So here's part of the problem. The maximum amount you'd get on that would be $520. Okay. And just at this current number, that would bring you down to what? About, well, a little over 4, whatever it is, over 4. For Hawk to help you, you got to be down at 3.
I can do that.
So how are you going to?
I pretty much will be giving them money orders every week because I get paid
Pardon?
weekly.
You get every week, you get paid. So by next week, how much are you going to be able to pay?
Next week, I'll be able to give them at least 350, 400 on that. Because I do have other bills I have to pay as well, and I'm
No, I know, but I guess,
myself.
okay, so here's,
My other partner,
Ms. Harris, I'm just trying to figure out how we get you there. Okay.
yes,
Okay, other than DHS, have you reached out to any resources?
I don't have any more.
Pardon?
I don't have any more.
Okay, but
Used to this process.
you haven't talked to, you tried DHS, I get it. Have you reached out to SOS or Hawk?
I didn't know about them.
You didn't know about them.
No, sir.
Here's what I'm going to want you to do. Amy's here, but she's in the... You didn't file the... Yeah, Miss Harris. Did you know you should have filed the rental assistance form with the court? Did somebody tell you that last week?
No.
Well,
Just
hold on a
went
second.
over our case.
No, she did. I know what you, okay, I see what you did. Okay, you did do it. You didn't use our form. She filed a copy of her whole application, which we probably won't keep in the file, but she did what. So that's going to buy you another week. Okay. So what I want you to do is I want you to pay the $350 or thereabouts that you can this next time. Okay.
Yes, sir.
Now here's the other thing. So I'm going to adjourn your case out to the 20th, 2026 at 1 p.m. That's an in-person again. Okay. But now what I want you to do is I want you to go down to my clerk's office and let them know she's coming down. They're going to put you into a room, so they'll put you on a computer. I'm going to have you talk with our court liaison officer
Yes.
about resources that might be available to you.
Okay.
Okay? So that we can at least, if we can find a way, we can try to get that started.
Yes, sir.
Fair enough?
Yes,
Would that work for you?
Yes, sir.
All right. So at least you know what's out there and available to you. You're welcome. All right. You go down there and they'll take care of you down there.
Yes, sir.
All right. If nobody gets you into a room, you come back down here. I don't want you leaving the building. Okay. Northfield Estates versus Christopher Welke.
This exchange highlights something many viewers don't realize. Eviction court isn't just about rent. It's also a gateway to emergency housing assistance. The judge is actively directing the tenant to a court liaison and local aid programs, essentially pausing the legal process to try to stabilize the situation. But notice the threshold rule mentioned. Assistance agencies often require tenants to reduce arrears below a certain amount before funding kicks in. That's why the judge pushes for weekly payments, even small ones, to get the balance under eligibility limits. This is where eviction cases often turn. If assistance arrives in time, tenants stay. If not, the case resumes and eviction proceeds. Timing becomes everything. So think about this. Should courts take on this kind of social service role? Or should their job stop strictly at enforcing leases?
Name?
Christopher Welke.
All right. And how much does plaintiff have owing on this?
Your Honor, Mr. Welke made a payment today. I believe it was for 200, but I'm going to double check to make sure I just did my math properly. Assuming that that $200 payment is correct, and I believe that it is, the total with cost would be $2,129.29. And yes, that is a $200 payment made today.
How are you gonna get this? How are you thinking?
Well, I got money that's on its way. It's gonna be no problem to pay it off in full once that hits. But until then, I just gotta work with my unemployment every 2 weeks. I do want to know.
Okay, so, all right, I hear you. So when do you think the money's gonna come in for you?
I'm hoping before the end of this month.
Okay,
And then that's gonna put me, I'm gonna pay off this and on top until I'm back to work. It's taxes. I'm just waiting on my taxes.
so, okay, I just want to make sure I understand what your plan is. You'll be able to, if that comes in by the end of the month, you should be able to get this paid off.
This paid off and then a month ahead or 2 months ahead.
Oh, you're trying to get yourself, oh,
Yeah, because
I
I
got
got to be laid off till like March probably.
Okay, I got you. So here's what I'm going to do, sir. For no tribal issue after a hearing in this matter, I'm going to grant them a judgment that basically just at least freezes this amount at the 21, 29, 29, I think it is. And I'm going to extend your writ date out to the 27th, basically to the end of the month.
Okay.
Okay. And then that way, the object for you would be to get it there.
Okay.
And then hopefully then you'll be good.
Okay.
All right?
Sounds good. And I got a question. This paper right here that's in my packet, where do I turn that in at?
What is that for?
It says, please, it's just a form before the contact information amend for the court.
Oh, okay. If you can turn that in up front at the front counter if you want to.
Okay.
Okay, that'll work. All right?
Thank you.
Thank you, sir. Scio Farms versus Derek Wanchon. And Elizabeth Wanchon. How are you guys?
Good.
Good? Okay. Let's see, where are we on their case?
Bear with me just a moment, Your Honor. I think I've got too many files today. I'll locate it. Nope, that's annoying. Well, let me try that another way.
All right, well, you look for that. You guys had your meeting with Hawk?
You want me to?
Yes, we did. They referred us to the Ann Arbor Housing Commission,
Oh, they referred to the Ann Arbor Housing Commission.
and we just got a phone call from them today before we stepped in.
Yeah.
Okay. It's progress. Don't worry about it. Okay, what'd they say?
I got to call them back because I didn't want to call them while we were in here.
Pardon?
I got to call them back because I didn't want to call them while we were in here.
Okay, so you gotta call them back today?
Mhm.
Yes, sir.
And they want you to do what? Just call them back and,
Send in verifications of our IDs and everything in the ledger.
okay, so you gotta send in, so basically the process that you go through with Hawk, but you're going
Yeah.
through with Ann Arbor Housing. Okay.
Your Honor, if I may, I had been in contact with Hawk as well today. And they did confirm that they had referred defendants to the Housing Commission. And that the Housing Commission does kind of have a similar process. Did they already submit their application then to the Housing Commission?
I don't think so. I think they had their appointment on the 9th. I don't think they were informed of the Ann Arbor Housing Commission. They just got a call before they came down, right?
Yeah.
Here, so they were gonna follow up on that. So they don't have everything.
I wasn't sure if the application had prompted the phone call or just the referral from Hawk had. So we're still in the very beginning stages of the Housing Commission assessing them for assistance. Is that okay?
So here's what I'm gonna do. I know it's had a couple of, but I'll work with you. So I'm gonna adjourn it out another week. Okay. And because what I was hoping by getting to this date that we would have something from Hawk, but now you've been sent someplace else. So that's not anything that from what you guys are doing. So I'm gonna adjourn it out one more week. Get to Ann Arbor Housing Commission right away to get that process going. Okay. Now, have you been paying anything all along or no? How are you guys?
Not yet.
Our tax return should be hitting this week. Oh,
Okay. All right.
hopefully.
No, I hear you. Okay. I just wanted to make sure. So the 20th at 1 p.m. Okay, that'd be next year. Go get started on that Ann Arbor housing thing right away.
Sure.
All right, let's get that rolling. Okay, folks?
Okay.
All right. Keep good spirits
All right.
and try to have a good weekend. All right.
Thank you.
All is not lost. Okay. Sile Farms versus Arkeem Kirk. Arkeem Kirk, not here. I think I swore you in earlier. You may proceed.
Thank you, Your Honor. There is rent to retain of $818.35. Costs are $230 for a total due of $1,048.35. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested with the writ issue in 10 days. Sile Farms versus Shannon Rousseau.
Hello, Your Honor.
Hello, sir. Your name?
Shannon Rousseau.
All right. And where were we on his case?
We are at $3,194.65, including the costs.
All right.
Okay,
What
my
happened?
intention, well, I hope to have had the money by now, but if I could pay January's, which would, I think, 22 something on Monday, I could pay then the current to pay the total 31 by the 26th, so an additional 10 days. That would be, then I would,
So you
I would be
think
current
you
by
get
this.
everything paid by the 27th?
Correct.
You can?
Yes.
All right, here's what I'm going to do. Finding no tribal issue after hearing in this matter, I'm going to grant a judgment. That was $31.94.65.
65 cents, that's correct.
All right, I'm going to grant them a judgment for that that total amount. All right. You would normally have to have this paid by the 23rd, but what I'm going to do is I'm going to extend the writ date out to the 27th of February.
Thank you.
Okay? And so you get everything paid, you're all set? All right. Thank you. Court calls the case of Sile Farms versus Eric Jackson. Hello.
Your Honor.
Your name?
Eric Jackson.
All right. And what's the claim in this case?
This one, Your Honor, we are at $4,341.69.
All right. How are you getting this paid, Mr.
I
Johnson?
was relying on my tax.
Pardon?
Oh, sorry, I'm a little bit sick right now. I was waiting on my tax money, but it hasn't come in. I told them I'd have at least 200 by Friday today, and I don't. So I'm honestly just
You don't have it?
gonna ask if there was any way I could maybe get until like the 1st to move out.
Pardon?
I was gonna ask if there was any way I could get maybe until like the 1st to move out.
You want to move out by the 1st? Okay.
That's an option.
Well, here's what I'll do.
Your Honor, just so the court is aware, Mr. Jackson owns the manufactured home. So what is his intentions for the home?
Yeah, what are you going to do with the home?
Probably just give it to the park.
Pardon?
Probably just give it to the park.
Give it to the park?
Yeah, or maybe try and list it for sale.
Well, I don't know that they do it that way quick.
He's gonna need to contact the lender, Your Honor.
Yeah.
Maybe an option for him to surrender it to the lender. I don't know specifically in his case, so he needs to talk to them about that. But he wouldn't be able to surrender it to SIO since there's a lien on it.
Okay.
Okay.
So here's what I'm going to do, sir. Since there isn't a tribal issue for the court, I'm going to grant a judgment to the plaintiff for possession in the total amount, redemption amount in the total amount paid for. I'll give you, because you're going to have to go in and you're going to have to talk to the landlord. I'll give you to the 27th in case there's a miracle. I'll give you to the end of the month to try to get that done.
All right.
All right. But I'd suggest that you talk to them, talk to your lender, and see what you can do about the home itself.
All right.
All right. Thank you, sir.
By this point in the docket, a pattern is unmistakable. Multiple tenants are relying on tax refunds to resolve rent debt. Judges hear this constantly during tax season. Promises that once refunds arrive, arrears will be cleared and stability restored. Legally, though, courts can't base decisions on money that hasn't arrived. That's why you're seeing judgments entered but writ dates extended. It freezes the debt amount while giving tenants a narrow window to pay before eviction enforcement begins. It's a legal compromise. Landlords secure a judgment, tenants get time, and the court keeps the case moving. But it also reveals how fragile housing stability can be. One delayed refund, one lost job, one illness, and eviction suddenly becomes imminent. So here's something to consider. Should anticipated income, like tax refunds, count when courts decide deadlines?
Shire Farmers, this is Carol Stafford.
Rachel Dornbush, Palace Law, on behalf of the plaintiff.
And Tara Stafford, I guess. Hello.
Good afternoon.
Your name?
I'm sorry, I'm a little sick right now, he says quietly. He explains he was waiting on his tax money and promised to have at least $200 by today. But he doesn't. The judge asks directly, "You don't have it?" He admits he doesn't. Then he asks if there's any way the deadline could be moved to the 1st. The courtroom pauses. The judge weighs the explanation against the obligation. Deadlines don't simply disappear because money is late. So here's the question. Should courts extend deadlines when someone is genuinely struggling? Like if responsibility should still matter? Share if financial hardship should be considered?
Here's what I'm going to do, Mr. McLean. I'm glad you brought that to my attention. I'm going to adjourn this 1 week. Mr. Friedman, I'm going to ask that you check into it, and either that $998.16 is refunded to Mr. McLean, $998.18 is refunded to him immediately, or, well, I'm going to put it this way. Mr. McLean, you want that credited to your account, or you want the money back?
I'm fine with it being credited. I'm just not sure about it. I do assume some fee could be charged to me, but I just feel like that was excessive.
No, yeah, there are certain legal fees that can be charged. I don't know where this $998 comes from, but somebody, Mr. Friedman, I'm going to adjourn it out a week. Mr. McLean should get a ledger. I should get a ledger indicating that amount in full is credited, and I'm not, and so you can let your client know, because this is very illegal, that I'm not allowing them to charge any legal fees as it regards that. I want the whole $998.18 credited to him.
I understand, Your Honor. I'm not,
All right.
I'm not troubled by
Mr.
that.
McLean, if you send a ledger, I don't need to see you, and if I have it, if I don't have the ledger, then I'll need to see you next week, Mr. McLean. And then I'll take other action as necessary.
All right.
Okay? Thank you.
Thank you.
1 p.m. That's the 20th at 1 p.m.
Okay.
Thorncrest Property Group versus Linda Gibson and Janae Jones.
Ellis Friedman for the plaintiff.
Gibson and Jones. They are not checked in. Did I swear you in previously?
No, Jones said she was going to move, but
Said she was going to move?
Yeah, she hasn't yet that I know of. And
all right.
She hadn't.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, go ahead, sir.
This is a termination case. Ms. Jones was served. Ms. Gibson is incarcerated, has been for years. And Ms. Jones said she was going to move, but we don't have the keys. So I'd ask for a judgment of possession.
Judgment to the plaintiff. That's by default for possession. No redemption amount, writ to issue in 10 days. Thorncrest Property Group versus Ashley Hines Walden.
Ellis Friedman for.
They are not checked in. You may proceed.
This is the same situation, Your Honor. It's a termination case, but she has not, and said she was going to leave, has not turned in the keys. As for judgment of possession only.
Judgment to the plaintiff by default for possession, redemption amount. There is none. Writ to issue in 10 days. Thorncrest Property Group versus Richard Yost.
Ellis Friedman for the plaintiff. Same thing, Your Honor. Mr. Yost said he was going to move out, but we haven't got the keys.
Richard Yost. All right. I'll grant a judgment to the plaintiff by default for possession, redemption amount. There is no redemption amount. Writ to issue in 10 days. Thorncrest Property Group versus Tanisha Roberson.
Ellis Friedman for the plaintiff.
Alex Henry, entering an appearance for Mr. Roberson, who's awesome.
All right, where's Miss Roberson? Come on out.
Hi.
Hello.
How are you?
I'm doing well. Yourself?
Good, thank you.
All right, what are we doing on this case?
I was able to reach out to Mr. Friedman, and I think we're working on a conditional dismissal where she would move out by March 1st, if that's what we agreed to, Mr. Friedman.
Yes.
Do you want me just to adjourn this out 1 week, or is she gonna?
That should be enough, Your Honor. I can get that in probably this afternoon.
Well, okay. Let me just say this. Are you planning on moving out by the 1st?
Yes.
So, folks, why don't I adjourn this to March 6th? If she's moved, it can be dismissed. Unless you guys really like doing paperwork. Would that work for you, Mr. Friedman?
I don't know why not.
No issue here, Your Honor.
I guess,
No issue? Okay.
I guess, Your Honor, the only problem I would have is if she doesn't move, then she's going to get 10 more days from March 6th. That's the only reason I would have a problem with that.
All right, I'll do this. I'm going to turn it out to March 6th. If you don't move, I'm going to shorten the redemption period for the red. Fair enough?
Yep.
All right.
Thank you.
That way I don't have to read the stuff when it comes. No, I'm kidding. March 6th, 2026 at 3 p.m. All right, thank you. Court calls the case of Thorncrest Property Group versus James Reynolds.
Ellis Friedman for the plaintiff.
Oh, there he is. Your name, sir?
James Reynolds.
All right. Where are we on the, this is a termination?
Yes, sir.
And sir, what are your intentions or what's your position on this termination?
I was basically asking about the same thing for no more than a month.
You're asking for what now?
No more than a month.
to move. I don't know. Do you have any leeway, Mr. Friedman?
Can I get say more?
Remember, this has already been adjourned 2 weeks.
Yes, it's already been adjourned 2 weeks. So are you just asking for 2 more weeks?
Can I get to the March 6th? And I'll be up on March 6th too.
All right, well, here's what I do. That, if you're looking at the last case, that was actually going to be a move out the 1st. So what I'll do is, if I were to grant a judgment, because there's no defense in this, it would be the 23rd, right? But over the objection of plaintiff, I'll extend it to the 28th, so that gives you to the end of February. Fair enough? I'll issue a judgment finding no tribal issue after hearing in this matter. Judgment for possession. The writ date on this will actually be March 2nd.
Yeah.
March 2nd. All right, but you got to be out, or otherwise they're gonna move you. Got it?
On March 2nd?
No, March 2nd.
Second.
The 2nd.
Okay.
Okay? Thank you.
Thank you, Your Honor.
Thorncrest Property Group versus Charles Watson.
Alex Henry on behalf of the defendant, who is also present.
Hello.
How you doing, dude?
I'm doing okay, Mr. Watson. How are you?
Not too bad. Got this bad heart. So to change. Okay. Why my heart been giving me problems?
With Mr. Friedman yesterday, I think it was the same kind of discussion, or March 1st.
Yeah.
So are you gonna?
Yeah, I'm gonna move because I already got a place. I just got to have this thing get to my heart on the 24th.
Okay, so are you gonna be able to be out then in time?
Yes, sir.
So if I just adjourn this out to the 6th, you gonna, Mr. Watson, you promised me you'll be out by
I'll
the
be going
1st?
way for the 6th.
Huh?
I'll be going way for the 6th.
So if you're not, I gotta come get you out myself?
You got to come and get
You,
me.
no, I'm gonna bring Alan. We're gonna come. Bring Alan Bates. We all gonna come and get you out. You don't want me to do
No,
that,
I don't
though,
want you
right?
to do that. I got
Okay. Okay. Without over the objection of plaintiff, what I'm gonna do, I'm gonna adjourn your case out to the 6th, 2026 at what? 3 p.m. And if you're out, I don't need you here.
Yeah, this won't be like a thing that go on your record when you get a place with it.
No, as long as it'll be dismissed as long as you're out.
Okay.
Why, you think I'd do that to you? Huh?
Yeah, it was
You know, yeah, come up here, wave at me, and then say, I don't trust you, Judge.
Yeah, it was good thing, you know, me and my wife.
Yes.
I was in the guy that was driving that day.
Yes.
He said, just a minute, just a minute.
Just a minute. Yep. All right. You take care. All right.
This docket captures eviction court in its most human form, not just legal rulings, but real-time negotiations between hardship and obligation. Across these cases, the judge repeatedly used the same framework: verify the debt, assess payment ability, connect tenants to assistance when possible, and set firm deadlines when necessary. Some tenants secured extra time through partial payments or pending aid. Others received judgments with delayed enforcement dates. And in every case, the underlying principle stayed constant. Rent owed remains legally enforceable, even when circumstances are difficult. What stands out most is the balancing act. Courts aren't purely punitive, but they also can't ignore contracts. They operate in the narrow space between empathy and accountability, and outcomes often hinge on timing, documentation, and follow-through. So now we want to hear from you. Should eviction courts lean more toward compassion or strict enforcement? If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thorncrest Properties versus Melissa Slosh.
Alice Friedman for the plaintiff.
She is not checked in. You may proceed, Mr. Freeman.
Your Honor, this is a termination matter. She's been served. Actually, she appeared last time.
Yes, she did.
And I'm asking for judgment of possession with a written 10 days. I guess the writ date's 3/2/23. Oh, yeah.
Judgment to the plaintiff. That is by default for possession. redemption amount in the amount requested with the writ issue in 10 days. Thorncrest Property Group versus Caitlin Lamerson. That matter's dismissed on plaintiff's motion without. I think that's it for you, sir.
I think so, Your Honor.
All right. Have a great weekend.
As you can see, I'm having gonna have a real good one.
You're what?
I said, as
I
you can
see
see,
the
I'm gonna
trees
have
in
a
the
real
background. You don't have to rub it in.
I feel obligated to do it.
I see. All right, sir.
See you
Take
next
care of
time.
yourself, please.
Thank you.
Thank you, Mr. Henry. Arbor Woods versus Roy Williams.
Good
Terry will-
afternoon, Rachel Dornbush, Pallet Law on behalf of the plaintiff.
Yes,
Oh, I'm sorry. And Terry Williams.
yes.
Oh, she's following this. The corner. All right, where are we on this case?
Bear with me just a moment, Your Honor. I'll look at her figures. We are at a total with costs, Your Honor, of $978.30. Your Honor, Ms. Williams had been in communication with Ms. Fontanille in my office with some questions regarding some line items on her ledger. If Ms. Williams prefers, I can meet with her in a breakout room to go through those with her, or if she just wants to go over them on the record with Your Honor. Either way, I will defer to her in that regard.
Ms. Williams, what do you want to do?
I'm very confused on why I still owe, only because I've been paying my rent. So I don't know what I owe because I paid it every month. So
All right.
yes.
Here's what I'm going to do. Ms. Williams, I realize you're on with the phone, so just wait on the line, okay? I'm going to get through these other cases and then put you and Ms. Dornbush into a breakout room and see if you guys can clear that up.
Okay.
Okay?
Thank you.
So just sit tight. All right.
All right.
Thank you. Woods versus Felicia Hugan and Reginald. I like Felicia better. He knows that though.
She just won't take off work.
What?
She won't leave work.
She won't leave. No, that's fine.
That's fine. That's the
All right.
We are at, Your Honor, $2,125.92.
All right. Basically where we were last week. How are you guys going to get this done?
23rd, I probably have 1,500. Then that next week, pay it off. So 23rd, 27th,
So by the 23rd, you'll have 1,500.
Yes.
And then
27th.
That Friday? The 23rd, the Monday.
Yep. By that Friday. Yeah.
Then by the 27th, you can pay it off?
Yes.
Okay, here's what I'll do. I'm going to find no tribal issue after a hearing in this matter. Grant judgment to the plaintiff. By default, as to Felicia. I'm finding no tribal issue as to the whole issue in any event. But what I will indicate with the writ issue in 10 days, if defendant pays $1,500 by the 23rd, which would be the writ date, then the writ is extended to the 27th.
Thank you, Your Honor.
All right. You got that?
Thank you, sir.
So you got to make sure, so that we're clear, what I'm doing is you got to make sure to pay that $1,500 by that date.
Right.
And then that will give you to the 27th to pay the balance off.
Thank you, sir.
Fair enough?
Appreciate it.
All right. You take care. Have a good weekend.
Thank you.
Tell Ms. Egan I said hello.
Thank you.
All right. Court calls the case of Arbor Woods versus, is it Sanisha Thomas? I messed it up. Don't yell at me. You start screaming at me, I'll cry.
I'm Katanjanika. I'm the mom.
I'm sorry?
I'm Katanjanika Thomas.
Okay. You're an occupant.
I'm the mom, but I'm
You're
on
the
the
mom.
booth. Yes,
Okay. You're an occupant
yes, sir.
in the premises? Okay.
Yes, sir.
All right. How much is owing on this?
With costs, Your Honor, $3,061.55.
All right. How's that going to get paid?
The 20th, next Friday, I'll be able to do 15 and then
How much?
1,500. I will say more, but I want to say it because I already messed up one time saying something and I didn't get a check. So I just want to be clear.
So you have 1,500,
On the 20th.
and then what? How's the balance going to
Can
get
I
paid?
can I do it on the 6th?
Of March? The problem is your March rent is going to click.
I know.
Have you reached out for any assistance?
Yeah, I was planning on it, but we haven't yet. No.
But you didn't?
No, I have not. Not yet. No, sir.
Have you?
Only reason
you
why-
haven't called Hawk
No.
or SOS?
No.
Is there a reason why you haven't done that?
Because I'm working, I just had a mishap of garnishment. Now I'm not getting garnished. That's the only reason why I didn't, but
Right. Okay, I get that, but you got to find some way to get over this hump, or you guys are going to be out.
I know. I can call them, but I did.
Okay. You have the number?
Yes, I do, sir.
All right. So here's what I'm going to do. I'm going to find no tribal issue. I'm going to grant judgment for possession to the plaintiff, so we're at least locking in this figure. All right. If you call them, I'm going to have the writ date be the 27th, February 27th. If defendant pays, you said you're going to pay 1,500 by the 20th?
Next Friday.
1,500 by the 20th. Probably should say that better. Writ date is the 23rd. If you pay 1,500 by the 20th, your writ date's extended to the 27th.
Okay.
I'll say it that way. That's what I meant to say, but I said it in a backwards way. You got that?
Yes, sir.
So I'm going to suggest, particularly since you're not going to have a paycheck until the 6th, that you get yourself to Hawk so that hopefully they can cover that part.
No problem.
Okay?